Good afternoon, everybody. We might just give it another couple of minutes just to let people enter in, and then we'll get cracking. Good afternoon, everybody. Welcome to our Small Business Restructuring webinar from Cathro and Partners and held conjointly with RBG Lawyers here. So today we're going to be talking about the small business restructuring and I guess whether it's actually worked. My name is Declan. I'm the Queensland State Manager of Cathro and Partners, and today I'm joined by Matthew Rodgers, who is a Senior Associate at RBG Lawyers. So you guys are...
Thanks Declan. Yeah, so we're a small boutique insolvency firm. We do a lot of things across both solvent and insolvency land. It's very good to be a part of the cutting edge of new developments that are happening and critiquing what is and isn't working.
Okay, so I guess today, from an overview perspective, we're going to be talking about the small business restructuring process. Secondly, the simplified liquidation process. Third, a comparison of these options against voluntary administrations and liquidation processes that are already in play and continue to be available. Fourthly, we'll review the outcomes of the SBR processes to date. And 5, how the corporate insolvency inquiry may impact the small business restructuring process going forward.
I think it's also important at that juncture to note that we don't have a lot of complete information about how these things are developing. So a lot of that point about where things will go to, we are proceeding on some incomplete information. And that's something that's only going to be addressed, I think, over time.
Okay, so we've got the small business restructuring process. So it came out on 1 January 2021, and so it's still quite new in its infancy and things here. So Matt, would you like to give us, I guess, a bit of an understanding of what was the idea behind this and why did it come into play?
So the idea behind it is we've got to keep in mind the context that I think everybody's sick about hearing, which was the onset of the coronavirus pandemic, and the fact that we were dealing with a lot of companies that were small, may not necessarily have resources that traditional insolvency methods could deal with adequately. So I think one of the intentions behind this restructuring process, and this is drawn from some of the explanatory memoranda that went before Parliament, was that it was also to provide an alternative to the one-size-fits-all approach. So it's designed to almost be a form of Dr. Light, I think is the phrase that people like to throw around, although what we will come to later is that there's a strained relationship that analogy relies upon. The ultimate aim, of course, is to deal with and assist companies that have what they would call non-complex debt. And unfortunately, one of the realities is a lot of the time we don't necessarily structure the affairs when we're in the midst of running a business. The old expression of that, running a business is a lot like building the plane whilst you're flying it, is something that means that once you get to this predicament, calling a debt complex or non-complex is a bit of an arbitrary assessment. Turning to the process itself, I'm in the first step, and then Declan, you can lead us the rest of the way. But the directors first have to recognise that there's a distressed company and have to decide, that there is some issue relating to insolvency and form a relevant opinion. The practitioner then has to be approached, and they'll deal with their particular engagement and consider first and foremost whether the eligibility requirements could be met. If they can't be met, then this is all academic.
Yep. So I guess the idea of the small business restructuring process is that it's sort of, as Matt was saying before, VA light. So again, we've got these time periods that we start up. So the first part is there's up to 20 business days where comes in. First off, the appointment is essentially accepted because the directors have said that they're insolvent, and then they are eligible to form part of this SBR process. Then you've got the notice of process commencement is provided to the creditors, so by email basically. So we send out 2 pieces of correspondence via emails to all of the relevant creditors, and it just gives them sort of information about how this all goes and the process that's going forward. This is, I guess, quite similar to the VA process, where after a couple of days, you send out that first initial notice about the first VA meeting. Similar process here, except there's no actual meetings for it. Then during that process, a restructuring plan is developed by the company's directors in conjunction with the practitioner. So we're here to see whether or not it's actually a plan that's going to be viable to be able to then get the return to creditors later on by assessing their financials and other information and books and records that we provided during that 20-day business period. And then the plan is then provided to all of the creditors, as well as a certificate from the practitioner to say that yes, it's all good, and creditors are then given all of this information to see whether or not they're going to agree with the proposal. During this whole time as well, it remains with the director in control of the company. And this is a big change comparatively to the VA process, where the practitioner is the person that is generally in control and is usually there working a bit more hand in hand with the directors to make sure everything's there. It's sort of flipped in this particular type of appointment. Matt, is there any particular reason why, I guess, we've gone with this debtor in possession model?
My view, and I think the old adage of asking 10 lawyers will give you 11 opinions probably rings true on this, but my view relating to it is that it's all about speed. And the people who are currently running the business are probably the people who best know where the material is, and if they are being genuine, how to marshal that material to develop an effective plan, rather than in your VA or liquidation scenario where you have a practitioner coming in. The directors may not necessarily be helpful, and they've really got to try and reconstruct the world. So I think in order to achieve the speed and the speedy results that this amendments were designed to achieve, that's one of the reasons that we've tried to adopt this debtor in possession, more US style model to insolvency. That said, I think it's important to note that whilst the directors do remain in possession of the company, in control of the company, they do not necessarily have the same extent of powers. They can still bind the company, but it's really it is limited compared to what you could expect. But it really just enforces what genuine directors should be doing anyway. The only other point I think to keep in mind during this process is you need to keep abreast of the fact that there may be extant winding up proceedings that are currently being heard. This process can be a way of adjourning that particular application. The test for assessing whether or not that's got some validity is the same as when you are trying to place the company into administration, and that is it better for creditors that this restructuring occur, or whether the company be placed in liquidation? That's something that the directors and the practitioner may need to work together to come to a bit of a view on that, because particularly given the size of these administrations, taking such a forceful step to defend such an application can erode valuable resources that you're trying to preserve for creditors.
So probably, I guess, at this stage, given we'll probably go into it a bit later, but the quantum of the debts as well as probably the assets that are available or would be available from the SBR process is not likely to be worthwhile, I guess, trying to push off the winding up proceedings or try and get them dismissed, because again, we're just not talking about assets or debts that are big enough. Is that the idea?
That's the idea. It's hard, if you've got $100,000 worth of assets, it's hard to say that a particular process will benefit creditors if you're eroding 30,000 of them just having the argument. So I think that's the practical and commercial way of looking at how those applications may be handled. Victoria's got some helpful guidance, and hopefully it tracks its way up here.
Right, so after the 20 business days, and the practitioner has then sent out the report that has the plan in it for all of the creditors. The creditors then have up to 15 business days to vote on the plan and verify, I guess, their debt. And all of this has to be done by electronic means. So the idea is to keep it all nice and quick, as opposed to a bit of snail mail anymore these days. And the thing to keep in mind as part of this is that related creditors cannot vote on this process, and it has to be a majority of unrelated creditors by value who are responding by that deadline. We'll talk about it a little bit more, but shortly. And then after the 15 business days, we then have, it's either the plan gets approved, and that will then form into place, and the time periods for paying those debts or whatever it may be will commence, and the practitioner oversees that plan until the final dividend is paid. Or alternatively, if creditors vote against it, the whole process just ends and it automatically goes back to the director, and there's no automatic liquidation or any other external administration type that occurs at that exact point. I guess the process of the question I have for you, Matt, is like, how has this all come into play? How has this been legislated? I mean, it came in quite quickly during COVID, so how did they get around it to be able to put it in so that it was working within such a short period of time?
I mean, it's a good question. They were attempting speed, and when you attempt something with speed, you unfortunately may lose precision. One of the big boons of our democracy is we do have houses of parliament that can criticise and amend bills. The way that this has been legislated, with a skeleton being implemented by way of an act and the real mechanics being implemented by way of regulations, which for the non-lawyers are determined pretty swiftly by the executive or the ruling government. You do have some situations where there is a lack of precision in what we can expect. That I don't think there was a better scenario or a better solution given the circumstances. We do now have an insolvency review, so there is necessarily an opportunity to address that and to also take into account industry views about what has and hasn't worked, and potentially develop a more robust and appropriately legislated scheme. There was a lot of commentary from particularly legal industry stakeholder groups that considered this. Unfortunately, though, given the timeframes and the speed at which this was to be implemented, there is only so many words you can cram into a page at only one time. So the speed has really, I think, made this a bit more difficult, but in my view, there was not too much of an alternative.
I guess one of the points that I was bringing before is that so it has to be unrelated creditors who are voting on this. Is there any particular reason why this was implemented? I mean, I know that in bankruptcy, there's called a personal insolvency agreement in the Bankruptcy Act, which it's a sort of, I guess, a similar process, and they haven't sort of taken that on board to an extent. But it's all unrelated creditors. So is there going to be an impact for those related party creditors not being able to vote?
I mean, I do think that they're a necessary stakeholder, but I think the reason that they've been excluded from voting, but included in the benefits, is a matter of trust. I think you have a fundamental breakdown of trust when you see a balance sheet with a large amount of related party creditors, and particularly in situations where they may carry the day. The idea is to protect creditors as a whole, and if you've got one creditor which is related that can determine something, you don't get the necessary buy-in from the broader community. And I think that was perhaps one of the rationale behind allowing related party creditors to participate in the dividend, but not necessarily vote on the plan, is to preserve that status quo.
So why do we use an SBR? I guess there's a few sort of major reasons for it. So first one is that by using an SBR, you get a clean slate for the company. So as we say, drawing a line in the sand, all the debts prior get pushed over and they're back there, and the company can restart without all of those older debts still bogging them down and unable to really start making progress. That's, I guess, probably a major reason that they brought it in, particularly during COVID, when you had so many businesses with this historic debt. They weren't able to trade at the same levels that they previously were, and therefore they couldn't just get over enough to pay everybody back. So that's one of the major reasons there. The idea is that it's supposed to be lower cost. We might talk about that a little bit later, but the premise of it, because it's a debtor in possession, so the director is in control, as a restructuring practitioner, you don't have to get quite as involved in the knowledge and the understanding and the trading of the business to ensure that the business can then move forward at a lower cost, because they're not having to pay the practitioner for their learning time, essentially. You've also got the director in control, so it works hand in hand. They know the business, they'll keep it going. It's just as per normal with another advisor, essentially there. We're finding that an SBRs are getting a greater engagement with the ATO at the moment. So the ATO are appearing to want to get involved with these, so long as there is a genuine reason for using an SBR, and it is going to provide the company to keep trading at the end of it or get a better result than what a liquidation is. The directors also get protection during the period, so it actually counts as a sort of a safe harbour protection using an SBR. So all those insolvent trading claims for any debts made during the SBR process can't be attached to the director. And I think probably something that was maybe not necessarily thought about, but it was just a consequence of how it's currently legislated, is that it can actually be beneficial for some industries, like the construction industry, particularly in Queensland, for their licenses. So Matt, are you able to explain a little bit more as to why I'm saying it's beneficial for some of these companies to use an SBR as opposed to using a voluntary administration?
So I think the slide calls out the industry that's probably most ripe for it, and that's construction. Under the Queensland Building and Construction Commission Act, you have certain excluded individuals, and that can be triggered upon a VA, a liquidation, a receivership in respect of the company. That person does not become an excluded individual where an SBR occurs with respect to the company. So if you have a director who holds building licenses that they need to earn an income, an SBR may be a suitable way to try and A, preserve those licenses, but then B, also deal with a company where your other options are either extraordinarily risky in that they are informal and you are incurring a potential insolvent trading liability, or you go through something that can result in the loss of your licenses. That said, and I think we'll come to the eligibility requirement issue, is that whilst that is an industry in which there could be some real benefits, the manner in which we've implemented these eligibility requirements has, at least in my view, almost excluded that industry from taking advantage of this. So it's a benefit that could be obtained, but in my view is presently not.
So here we go. Who can qualify? So firstly, the company has to be insolvent, or it's likely to become insolvent. All the tax lodgements are up to date. Similarly, employee entitlements are up to date. And this is the big one Matt was just talking about, is your liabilities have to be under $1 million. So that of itself is going to knock out a lot of entities from being eligible to use this process. So another part is that the company has to be, or had not been subject to a simplified liquidation or an SVR in the previous 7 years. And then further to that, the directors, including former directors who are the former directors within 12 months, cannot have been involved in a simplified liquidation or SVR in the previous 7 years. Now that of itself is probably going to exclude a lot of people the further we get down the track, because, and maybe this is even something to consider, whether that's going to exclude people or directors and companies if you're having multiple appointments of an SBR at the one time. And I'm not sure whether you may or may not have looked into this matter or know or consider it, but it may just be some food for thought later on as to whether or not if you've got a group of companies, whether you can all put them through as an SBR or it's going to exclude them because of that condition there.
No, I think it is a point that at least it's potentially unclear. You can understand the underlying rationale that you don't want one director basically shifting between a lot of companies to force them into these processes, because then you start to lose the benefits. But at the same time, there could be situations whereby it's a corporate group that's problems arise, A, due to their related debts, and that their potential issues all arise out of the same factual matrix. I think if you are involved in, or there is a corporate group involved, making sure you get advice specific to your circumstances is probably the best approach, because there are a myriad of options available, and they will ultimately all depend upon the individual circumstances of your group.
So whilst I did just say that the tax lodgements and employee entitlements are up to date, it doesn't have to be at the time of the appointment of the SVR. They just have to be up to date and paid for the employee entitlements, at least at the time when the plan is proposed to creditors. And I guess a reason for that, as we're probably going to say later, is that the idea is that all creditors are equal, therefore you cannot have any employee entitlements that are outstanding because your 556 preferences are not going to be there. This is sort of, I guess, a little bit that we talked about before, but as we said, the process is it can only be initiated by the directors, and once it has started, the process cannot be revoked. There's two notices that get sent out by emails. First, the appointment, and then secondly, the restructuring plan, which is within 20 business days. Then the creditors will vote by email within 15 business days. And then after that, the plan is either accepted or handed back to the directors. Matt, can the 20 business days of the proposal period be extended? So similarly, in a VA period, you've got your ability to extend for up to 45 days, or you can go to court to get extensions. So can we do the same for an SBR?
Short answer is yes. there are two potential extension processes. One is an extension as of right of a further 10 business days, and the next is an extension by court approval. In order to get the maximum extension, my view is it's important to exercise the 10 business days first, because otherwise you may have lost the opportunity to use those 10 business days that you might need down the track. So yes, there are two different ways, but you might want to consider the precise ordering of how you take advantage of those potential extensions.
Yep. So is there anything else that maybe I might need to take into consideration as a practitioner or anybody else whilst we're going through this SBR process?
Yes, I think one important thing to keep in mind is, whilst it's touted as the practitioner has a lighter role, they are still an officer for the purpose of the Corporations Act, and so can be slugged with particular duties. In particular, the what we call the director's duties to under sections 180 to 183 of the Corporations Act. So whilst it is true to say you have a lighter role, the obligations imposed upon you may not necessarily be as light. It's a bit unclear what's expected of practitioners in those circumstances.
I think it's still early days at the moment, so it's a sort of wait and see thing as well to an extent. So I guess part of this, so we then have the restructuring plan is developed by the company's directors with the support of the practitioner, and we're now going to talk about what the different roles of each of the different stakeholders are whilst the SBR process is in play. So as the restructuring practitioner, their role is to provide advice on the restructuring, assist in the preparation of the plan, make a declaration of creditors to creditors. So that's more in relation to telling all of the creditors, one, what their value of the debt is, of their debts are, and then two, the assets position as well, and what is going to be that dividend that's going to be paid to them at the end. And then it's also the restructuring practitioner's duty to terminate the restructuring business plan or terminate the whole process if the company no longer is eligible or they determine that it's not in the creditor's best interest to continue with the restructuring proposal. For the directors, their requirements are to give as much information to the small business restructuring practitioner as possible about the company, allow them to inspect the books and records, and prepare the plan in conjunction with the practitioner. Matt, are there any further things in relation to the books and records that as a restructuring practitioner we need to maybe be aware of, or it's something that hasn't necessarily been completely considered at this stage?
Yes, I mean, the company is not always going to be the sole custodian of all of its books and records. Whilst that's something you might expect, particularly if we were dealing with, say, a company with non-complex debts, there's going to be third-party stakeholders that hold valuable information that will be necessary, particularly if you're dealing with things like tax lodgements and employee liabilities. For example, your everyday accountants who will be preparing relevant returns or looking after the bookkeeping side of the business. They're going to have very valuable information that the company either may not have at all or may only have an incomplete snapshot of it. And that's something that it's important for the small business restructuring practitioner and the directors to get a hold of. Whilst there's a right to inspect those books, the Act, upon my reading, doesn't go as far as what you might expect in a liquidation context, as allowing you to access or get copies of those books despite any asserted liens or some other type of security. So you can be faced with a potential deadlock scenario, particularly where relationships between the advisors and the company may break down on account of fees, which is not a situation which would be unheard of in an insolvency context.
Something else to consider as well is that, as Matt was saying before, the restructuring practitioner then is an officer of the company or an agent, things there. So, but the difference is that any of the liabilities that are incurred during the SBR process does not lie with the practitioner. They are not liable for any of the debts that are incurred during the SBR process.
The only, I think, corollary to that is, I mean, that proceeds on the basis that the practitioner's acting appropriately, particularly when they are acting as an officer. So there still needs to be some commercial thought behind what debts are being incurred, particularly given their quasi position.
And that's probably something to take into consideration, that if the company is no longer eligible or shouldn't be continuing with the process, it would then fall on the practitioner to make sure that they are terminating it when they get to that position as well. So in relation to the company, and during this process, the company controls its assets and its trading. It can only enter into transactions in the ordinary course of business or with the practitioner's or court's consent. Restructuring practitioner appointed needs to be put on all public documents, so in the emails, as you'd see for in liquidation or involuntary administration. And the big one here is that by entering into the SBR process, the company is automatically deemed insolvent. Similarly to your VAs, the secured creditors have a time period to appoint in an SBRP. So SBR, they have 13 business days to appoint, and the banker's liens apply. For unsecured creditors, they cannot commence or continue court proceedings without court approval or the practitioner's consent. They cannot enforce guarantees against the director, spouse, or their relatives. The sheriff cannot deal with the property or pay any proceeds, and there are no restrictions on DPNs. So similar to a VA process as well, so the landlords can't take possession without the practitioner or the court's consent. Shareholders can't transfer or alter the shareholdings. The court must adjourn the winding up application if it's in the creditor's best interests, and the liquidators can't set aside transactions in the ordinary course or were with the SBRP or practitioner or without the court's consent. I know that was a bit of a mouthful there. Is there anything else that stakeholders should be aware of when going through this process, like privilege or protections or anything else of that sort of light?
A lawyer is always very concerned about making sure that whatever legal professional privilege attaches to their advisors isn't going to be unwound at a later point. So I think to the extent that directors want to get some advice on where they can go to or what they can propose, and to get some second guessing, I think it's important that they reach out personally as opposed to through their company. We have to keep that in mind because the company is deemed to be insolvent upon the proposal being made. So if you have a situation where the plan is not accepted and the company is later wound up, any advices that directors might have obtained in the course of putting that together, if they were provided to the company and not to the directors personally, then that is something that a liquidator might have a look at down the track. Now, once privilege has been, waived or lost, you never really know where that can go. So I think that is an important thing that directors should keep in mind, that if they are going to seek legal advice as part of this process, it may be something that is better to be sought by them personally as opposed to as the company. Just because one of the reasons that a director may want to go down this process is to protect themselves. That's probably the key part, but any issue to do with legal professional privilege can get very complicated very swiftly. So I think it's important that that's something that is thought about early on rather than when it's already too late.
So something that I talked about there is that the company can only enter into transactions, excuse me, in the ordinary course of business or with the consent of the court or practitioner. Something that really stands out to me about this is that if this is a trading business and they have already entered into a payment plan or their cash on delivery with particular creditors and things like that, by entering into this restructuring process, is that, and maybe it's something that hasn't been worked out entirely practically at the moment, but it may force the business to not be able to necessarily continue trading. Because I can certainly see that as a supplier, if you are no longer able to receive that payment plan that you were receiving from them, you are probably unlikely to continue trading with the company. So those are probably times where you need to go get that court consent, or the practitioner needs to be able to waive those sorts of things. But I guess similarly in that, are there going to be implications from entering into those transactions if the restructuring plan doesn't complete?
Yeah, I think it's important to recognise, and this comes back to what I was saying before about this process works if it's built on enough trust between the rest of the community. Whilst you might not necessarily be able to set aside forthcoming payments that were made to continue on the business, because a liquidator can't necessarily set aside transactions that have got the court's or the practitioner's blessing, or in the ordinary course. That doesn't mean that there's not some other liability that could attach. That is only one mechanism of dealing with those particular transactions. By the same token, suppliers might not want to continue helping a company when they're not convinced that their existing debt's going to get paid. There's a difference between advancing a new supply and getting paid for that, but you might want to cut your losses and then put your business with a company that may be growing instead. So I think that's where there's a degree of trust, and the earlier you communicate with your creditors in these circumstances, the greater you can solidify that level of relationship with your suppliers and your other stakeholders to hopefully get a better result.
So what sort of information do they have to put into this restructuring plan? Well, the restructuring practitioner has to make a declaration that the company is eligible to make the plan. The company is likely to discharge the obligations of the plan. So that is, they will then be able to make payment of those monies or make enough profit to then be able to pay the percentages of whatever it might be. All of the information for the proposal has been provided. It identifies any matters that they could not form an opinion on about whether the company can discharge its obligations, and also that it identifies all related entities. For the directors, they are to develop the proposal restructuring plan and proposal statement. They are to execute it during the proposal period. They are to include their schedule of debt and claims and to assist the restructuring practitioner. And finally, the plan must identify the company property and specify exactly how it's to be dealt with. And it must also provide for the remuneration of the restructuring practitioner, and it will finally specify the date the plan is to be executed. So in relation to the property that the company is supposed to identify and specify how it's to be dealt with, I'm assuming that this is just, part of the ordinary course of business, that the property is dealt with in this particular manner, or is this that they've got a big asset and they can therefore get rid of it to pay for things, or is there anything else that, particularly in relation to that property, that people need to be aware of?
So I think when we're talking about restructuring plans, whilst we use the analogy as dock and light, there's some pretty significant differences between the two. And in some ways, the restructuring plan is light in the wrong way. One of the items is that the restructuring plan can only deal with the transfer of money. So in a situation where there may be an unnecessary, valuable, but illiquid asset that needs to be dispensed with and could result in some payment of creditors, that's not something that can necessarily be dealt with in the course of one of these restructuring plans. It almost deals with almost a trade out type scenario where we have some money and this is what we're willing to do, or this is how we can get some money and this is what we're proposing to do. It doesn't have the benefits that traditional dockers might have, particularly relating to share transactions, which can be forced, particularly when the company is, with a very minimal value or nil value. And that makes perfect sense when you consider the fact that the restructuring practitioner hasn't had the chance to go through and make a determination about what the value of the company is. The other item to keep in mind is that it treats all debts the same. And so you cannot necessarily have a differentiation or a preferencing scenario in particular relating to related party creditors. So you may not be able to have your related party creditor who's owed a very large loan agreeing to subordinate their particular debt for the benefit of the remaining creditors, which is something that you can often see in a docker scenario. So in those two ways, whilst the restructuring plan is designed to try and be flexible, it does miss on some of the very key things that make docker so beneficial.
So what happens if it's not accepted? So if it's not accepted, the process ends and the company is handed back to the directors. It's interesting to note that there's no automatic trigger to another external administration, such as like in a VA, you can then vote for the company to be placed into a liquidation automatically. In part of the restructuring, small business restructuring, there's no automatic trigger for that. So the company could then indefinitely be still trading in their normal state until maybe such creditor brings on a winding up application. And then something to bear in mind is that the company and the directors do actually receive safe harbour for the debts during that are incurred during the restructuring. Matt, have there been any court matters for SBRs really to date that you're aware of?
The ones that I'm most aware of have been to do with pushing out a winding up application. My view is the moment people start approaching the court relating to this, you start to lose the very key benefit, which is speed and cost. Unfortunately, any type of court application does come with a significant cost on both sides. And when you're dealing with a situation where the liabilities are, in theory, less than $1 million, the moment anybody's approaching a court to try and deal with some disputes, there's either a greater issue at play or you're about to consume a relative chunk of what assets could be available for creditors. And so I think for that reason, it's probably not foreseeable that there will be a large amount of litigation because there's just not a commercial benefit to it. I think another important thing to note, particularly relating to the lack of an automatic trigger to some other external administration, is yet you have a situation where there's a deemed insolvency by virtue of providing the proposal statement, and yet you can have a situation where an insolvent company is being returned to the directors. So how that situation might unfold, particularly relating to the directors, and what liabilities they might incur after the restructuring. That's an item which I think is a little bit less certain, and something that directors would be well served to have a discussion with their solicitor as to, well, this hasn't worked, now what do I do? I think they're probably two of the most important points to try and take away from a failure or a lack of uptake from of the proposal.
All right, so now we've got the simplified liquidation. So a lot of the same criteria apply in the simplified liquidation. So the main sort of parts that are sort of similar is that the debts have to be less than $1 million and the tax lodgements have to be up to date. Now the other parts of it are that it has to be a creditor's voluntary liquidation. Now that can be all of the different ways that you can have a voluntary liquidation occur. So on the termination of a DOCA, or where the creditors vote for a liquidation from a VA process instead, or just the normal shareholders resolving for a voluntary liquidation. And any of those other ones that sort of come under 489F, I think you've said that, Matt, to me previously. As part of the simplified liquidation, the director has to provide their ROCAP, so ideally doing it beforehand and showing the eligibility of the company. Similarly, the director can't have been had another company under external administration. Again, as we discussed earlier, there's going to be issues with that for wanting to use a simplified liquidation but being excluded from doing so. The ROCAP and eligibility declaration has to be provided within 5 business days. And as part of this process, you can't have more than 25% of creditors objecting to the simplified liquidation being used, and that this process needs to be proposed not more than 20 business days after the liquidator has been appointed. And it then also provides 10 business days for creditors to object to the process. So what are, I guess, some of the benefits of a simplified liquidation? So some of the benefits are that you don't have any reporting to ASIC. We should probably asterisk that one. You don't have any meetings of creditors. Again, no committees of inspection and no ASIC or creditors appointing reviewing liquidators. The big key one here, which is to, I guess, make it more simplified and less drawn out, is that you cannot have any preferences to unrelated parties for less than $30,000 or within the 3-month period. Related party stuff, that still exists, but the idea is to make this quicker and more simple. And the other key one is that there's only going to be one final dividend with no interim dividends. Now, Matt, something that is quite interesting about not having any of the reporting to ASIC, do we still, as a practitioner, have a requirement to go digging or identify offences, and what is the scope to that?
I mean, there is still some reporting obligation posed on the practitioner, but they are really tied with dealing with whether there's been offences or fraud. So a practitioner in the due exercise of their powers and fulfilling their obligations should do some level of investigation to determine whether there have been some offences or whether there's been some fraudulent type conduct. So to draw it back to the type of reporting, your Section 533 reports are not necessarily required in that level of detail, but you still need to do some of the steps that you would otherwise be expected to do for a simplified liquidation. And that increases both the time and the expense of running something that's supposedly simplified. But that's also of vital importance, because one of the reasons to move away from a simplified liquidation is that you have reason to believe on reasonable grounds that there has been some sort of offence or fraud related to the conduct of the company. So in order to perform that duty and making sure you're in touch with the company enough to understand whether or not that's occurred, you still need to do some investigation. So whilst that would be surprising, that there is some level of reporting, it really ties into obligations that are imposed on the practitioners indirectly anyway.
Just had a quick question, which is what is the usual costs of an SBR and restructure period as well as the plan period? I'd have to come back to you in relation to that. We haven't done any so far, but it's an interesting one where we'll probably touch on this a little bit more in just a second about it. We're not sure, one, whether it's quite as cost effective at the moment as probably what it could or should be. So again, unfortunately, it's not just a one size fits all, and we're finding that sometimes the costs that are involved are, whilst supposedly more simplified, isn't necessarily the case. And currently, in the way that it's all put in, I can't quite answer that as easily as I would like to, unfortunately.
I think it ultimately depends upon the circumstances of each particular company. The intention was that it was supposed to be a very low cost alternative because it's designed for non-complex debts. And yet, if you have a situation where there are intermingling debts between related companies and the bookkeeping might not necessarily be as pristine as you'd want, which is one of the big hurdles that practitioners face, that there is always going to be a situation where the small business liquidation or a SBR for a company in one instance may not necessarily be the same in another. So I think you're treating broad estimates is something that's should be taken with a grain of salt because that can change very swiftly.
Yeah. I'd probably say that currently in the process, in the current form of it, that both your simplified liquidations and your small business restructuring, probably not any different cost-wise to just a normal CBL or a voluntary administration in the most part, because unfortunately a lot of the same processes are having to be put into place, or the practitioner has a lot of liabilities or issues with requirements to provide information for an SBR, even when it's supposed to be more simplistic. So I guess this sort of goes hand in hand with this comparison side of things. So I guess the difference is for both the VA and the CBL as opposed to a small business restructuring and a small business liquidation is that you can have unlimited debts. There's no restriction of eligibility. So this is particularly in relation to those related parties not being able to then vote at the meeting. So this is particularly prevalent for a DOCA proposal where in an SBR, the related parties are completely excluded from it. And then I guess sort of probably the big key one at the moment is that currently, fortunately or unfortunately, Australians and in general are fairly well set in enjoying the current processes that we've got in place. And a lot of the practitioners are still much more experienced with the current VA or CBL processes. They know exactly what's going to occur. And whilst it's nice to have the debtor in possession direct control, some feedback hasn't necessarily been of comfort, particularly for creditors where they feel aggrieved about continuing with the same director there. So just a quick one in terms of the statistics of it so far. So as I said, it started in 1 January 2021. So in FY22, there were 70 SBRs with 37 accepted plans. So far this financial year, there have been 88 plans put forward with 62 accepted. I guess something that we have to note that is it's still quite slow on the uptake. I think some of those comments we've been sort of making throughout this is maybe explaining a little bit why it's been a bit slower to uptake, particularly the debt levels are the big issue with a lot of companies automatically being disqualified from even being able to do an SBR. What has been found is generally it's a lot of companies where they're only really remaining with an ATO debt. It just makes it a little bit more simplistic, but also then is this really achieving the purpose of an SBR where you're then continuing to trade, and what is the process afterwards? Do they then just enter into an MVL or something like that after the point? Part of the idea of an SBR is that you then have a trading company afterwards. And unfortunately, we don't necessarily have the statistics on that to say whether that's actually being achieved or not. Something to note is that the ATO is generally accepting of the plans if it is providing a better outcome than the liquidation. And again, they're showing that the company will continue trading from it. Then in relation to the small business liquidations, financial year 22, they had 29 in total, and then this year so far, there's only been 6. So this shows that, again, there's a real reluctance towards using a small business liquidation. I think just because, again, creditors want you to investigate the company properly, and in an SBL, that just doesn't exist. So, as you probably be aware, there is now a insolvency inquiry, particularly to look at this SBRs, the SBLs, the new insolvency regulations and schedules, practice schedules, with all the submissions that are due by 30 November 2022. We note that Arita is submitting a submission that was pretty much the same or very similar to what they've previously submitted to the government. So some of the things have been previously taken on board, but there are a lot of things that Arita are still wanting us to all see in relation to insolvency generally. I think one of the major things that's probably going to be required as part of this insolvency inquiry, and hopefully it is the case, that the SBRs need the higher thresholds. So Matt, like, this is based off the US sort of debtor in possession model. How is theirs working comparatively to ours, I guess?
I can't speculate how they're working, but I think in terms of the thresholds, I know that their thresholds are significantly greater, and that's before you start taking into account exchange rates between the jurisdictions. So you have a broader segment of the market that they consider to be of the size that can take advantage of a debtor in possession type model. That might not be appropriate for a jurisdiction like Australia, but I think it's important that we try and develop new solutions, particularly when we are dealing with the circumstances that have led us to these amendments. So I think, you know, the idea about the thresholds, as I talked about before, that particularly within the construction industry, the liability threshold is such that I think the most common the most common type of company that could take advantage of these processes has been largely excluded. So I'm not treating the numbers we've got so far with too much sincerity, because we're not getting, I think, a complete picture of the companies that are presently taking advantage of any insolvency options. So I think once we get some more time on the board, we might get some more complete information. But my view is the thresholds to take advantage of these processes are presently a bit low.
And then I guess finally, the thing that probably is going to help most with this is currently it's not cost effective to do an SBR or an SBL. So there needs to be a bit more of a simplification of the laws. And hopefully that might come into play. But that's all we have time for. Thank you very much, everybody, for attending this today. Our contact details are on there, or just send us an email through to the normal sort of processes. If there are any quick questions, we can jump to those ones now. If I can work out where it is. But otherwise, thank you very much, everyone, for your attendance today.
Thank you very much. Have a great rest of your day.